I'm Andrew Rowe of the Law Office of Andrew Rowe, and in this video I wanted to demystify your estate planning options in a situation where if it's your goal to divide your property equally to your children. Now, if you're married, this would only be after the death of the surviving spouse. These are some of the options available in a situation where you have adult children, you're not in a blended family, you're not anticipating disputes or squabbles, and there's several other factors that could go into this that we'd want to stray away from that. That's up to our office or your time with the attorney to unpack if there's anything that would get in the way of this. But this video really is kind of talk about some generalities about what options are available to you and the reason that you'd want to choose one over the other. So you have multiple ways to say that you want your property to go equally to your children. And I wanted to unpack those. You can either write a will that says, upon my death, split equally to my kids. You can go and list your kids as the beneficiaries of every account you have, every parcel of real estate, every business, that you do it an a la carte beneficiary designation. Or you could set up a trust, move your assets into that trust, and the trust itself says, upon my death, divide to my kids. Those three options all essentially accomplish the same thing. The difference between them is how we get from A to B, how we get the property from you to them. Each of them has their own pros and cons associated with them. So, wanted to talk about wills first. If you wrote a will that said, upon my death, divide to my children, or if you're married, upon my death to my spouse, but on the death of my spouse, equally to my children. Okay. Wills, yes, they say that, but wills only govern what happens in probate court. A lot of people don't know that. They think if I have a will, I'm avoiding probate. However, you need to look at a will as a letter to a judge who then enforces all of your desires through the probate process. Now, if you're not familiar, probate process is a set of state laws that are established to govern how to move property from you to your beneficiaries. This process assumes that everyone involved is not trustworthy, and because of that, has really complicated procedures to ensure that any action taken on behalf of the estate has been subject to the review of every beneficiary, creditor, interested party, and the judge themselves has to review and approve of every step of the way. It increases chances of objections, even when things are fair weather, even with a situation where no kids are squabbling or disputing, we know exactly what property is involved, and there's no debts. It's still expensive. It's many thousands of dollars to go through even a very basic one. And it can take several months, several years sometimes, even undisputed parcels. Just there's an issue with selling real estate, tax issue comes up if there's a boundary dispute. There are lots of problems that can arise in probate. So a lot of people seek to avoid probate. So wills would accomplish it, but it only is directing what's happening in probate. Your kids are having to take this 6-month to 1-year process, spending thousands of dollars to then have the judge approve every step of the process. So if you're wishing to avoid probate, that leaves the two other options. And the first is designating beneficiaries on every account, a la carte, or by setting up a trust. So next I wanted to talk about just using beneficiary designations to establish your estate plan. So this can seem like a very tempting offer. The benefit to it is that it is very cheap. You do not need an attorney to go designate beneficiaries on your account. So if you're married, if you own an account jointly, you designate children equally as beneficiaries. That's great. If you have like an IRA or life insurance where you can't jointly own the account, you can name spouse as primary beneficiary and name children as equal. That gets the job done. But what that skips is an important step to your process is the administration of your estate. After you die, someone needs to pay your taxes. Someone needs to pay your funeral bill. Someone needs to cover the costs of whatever costs arise as a result of your death. If you wrote beneficiary designations on every one of your accounts, you're writing instructions to the bank, just write a check, divide it by the number of kids I have, and write them checks. It does not hold on to the funds to ensure that they will be made available for payment of your taxes and expenses first. And if your kids get along and are trustworthy, that might be fine. That might be a good option for you. Usually what happens in that situation is that one child steps up and pays out of pocket for whatever expenses that you incur, and then has to ask for reimbursements from their other siblings to recompensate them for the out-of-pocket expense. If they're all trustworthy, that's one thing, but there are situations where those other siblings can lose their ability to reimburse. If any of those siblings are going through a divorce, lawsuit, bankruptcies, if they're on Medicaid, if they're disabled, or if they've died, they've lost their legal ability to reimburse that sibling who incurred those costs. And that is the other problem with real estate in this situation. If you have a house that you've then have listed your children as essentially a beneficiary, but you can write a transfer on death deed, which says, I take my house and transfer it to my kids upon my death. Well, upon your death, they don't want a house. The chances are they're not all going to be living in that house. So what they want is the cash from the house, is to sell it. It takes time to sell a house. And in order to sell it, it's going to take the signature of every owner of that house and their spouses. Kansas does require any spouse to sign off on the sale of real estate. So in that time, maybe it takes 6 months to get the house cleaned out and listed for sale. Every person who's listed on there can only sell that house if they have legal capacity to do so. So if they become disabled or if they die prior to the sale, we've put ourselves in a situation where it's going to take further legal action in order to get that house sold. So if any of them disagrees, if they won't sign, we're stuck. If any of them becomes incapacitated, we have to go to court to get legal authority just to sell their share. If any of them die before it's sold, their share has to go through probate. And there we are, we're back at square one, having to go through probate in order to get your house sold. The other risk associated with relying just on beneficiary designations is if any of those children do predecease you, we don't have an option to pick backup plans. We're not picking a responsible party who's in charge of paying your bills or selling the house or making the decisions. Everyone just has their money, but if one dies before you, you're subject to the bank's policies or the institution's policies about what's going to happen next. They may write a check to your state at that point for that deceased person's share, requiring you to go through probate. They may write a check to that deceased child's estate, requiring them to go through probate. They may write the check directly to the minor children of that person, and minor children aren't allowed to have property, so they'll have to go to court. But basically, you lose the ability to have nuance to your estate plan or backup plans. The whole point of a will or trust is we can write down the contingencies. What's going to happen next? What if they're deceased? What if they're disabled? What if they're bad with money? So relying just on beneficiary designations, while it seems an attractive offer, is very risky. There's a lot of risks associated with it, and it only works in very limited circumstances. I just patently do not recommend relying on beneficiary designations or transfer on death deeds if there's more than one child or if real estate's involved, because it's too easy for any of these conditions to come true, and then you're stuck at a place where you have to go through even more court than you would have if you would have just intentionally put this through probate with a will. So this leads to the final alternative of how to take care of an estate plan, and this is by setting up a trust. A trust is a document that's structured fairly similarly to a will because it's you stating who gets the property, under what conditions, and who your responsible parties are, but by its definition, it's designed to avoid probate while carrying out all of these steps. Now, one of the added benefits of the trust is that it is intended to hold all of your assets, to make them available for the payment of your taxes and expenses as they arise, and that you pick a responsible party that you choose and trust, put them in charge. They have the control of the assets so that they are first duty bound to cover your administration, making sure that all those costs are covered, the funeral bills paid. We've taken care of all the loose ends before the beneficiaries get their property. The other added benefit is it allows us to come up with contingency planning. What if any child dies before us? What if they're going through a divorce? What if they're on Medicaid or disabled? What if we have grandchildren involved too young to be inheriting property? How are we going to take care of them? A trust allows for all of this contingency planning, but outside of probate court, and would not thus be subject to the increased costs of probate at the time of your death. So the administration can take place much quicker. Instead of having to wait months to get access to property and start paying your bills, in some cases it can happen instantly. The same day of your passing, your next trustee can walk in and start taking over the finances and doing their job of completing your affairs. Those generally will be the three options available to you and are worth talking about and thinking over about weighing what's important to you when you're establishing your estate plan. If you're wanting to assume some risks with it but save on costs, if you're okay with probate, or if you definitely want to avoid probate and want your children to not have to go through the costs and expenses and complications or any of these pitfalls, to be looking into just how important it is to you to cover each layer of possibility with your estate plan. If you need help with your estate planning documents, we look forward to hearing from you.